DC 2319138, in re petition of BKM So1 Haran LLP, requesting deposition of the corporate representative of CWDL Certified Public Accountants. Council, make your appearances.
John Tufnell on behalf of the petitioner BKM Swan Haran LLP.
All right.
Your Honor, Chris Hanslick on behalf of the respondent, CWDL.
All right, let's proceed.
Your Honor, BKM has filed a Rule 202 petition in order to seek a pre-suit deposition of the corporate representatives of CWDL to investigate a potential claim or suit. And the burden, as the court I'm sure is aware under Rule 202, is does the benefit of the pre-suit deposition outweigh the burden? And we believe it does. By way of a brief background, BKM Swan Haran is an accounting firm here in Texas. CWDL is also an accounting firm, a competitor of BKM located in California. Over the past several years, going back to 2020, one of BKM's employees, Dustin Pfluger, who was under a employment agreement with my client, confidentiality, non-solicitation, he was hired away from BKM by CWDL. And with that, took some of our clients. An arbitration proceeding was initiated pursuant to that employment agreement with Mr. Pfluger, which was settled. 2 years later, Saba Basari, also an employee of BKM, left BKM's employment and went to CWDL. Again, she was under the same employment agreement that had confidentiality and non-solicitation agreements. She couldn't take her clients with her. She couldn't do work for any BKM clients for a period of time after her employment. Again, an arbitration has been instituted against Ms. Basari for her violation of that employment agreement. Why we're here today is to investigate, since there seems to be a repeated pattern of BKM employees being hired away to CWDL and my client BKM losing clients as a result of that. We're seeking to investigate that claim. CWDL is well aware, given the past arbitration with Pfluger, that BKM has these contracts in place with its employees. And it seems that they've continued to encourage people to violate those agreements and to tortiously interfere with my client's business opportunities. We are seeking to explore the extent of this to see if there is a cause of action to file against CWDL in state court. We can't, CWDL addresses in their response that we're attempting to take two bites of the apple, that we have third-party discovery, that we can do a deposition in the arbitration proceeding. But that would have to be limited to the arbitration. We're trying to determine CWDL's efforts to take our employees beyond Ms. Basari. We now know it's happened twice. We're trying to determine if it's happened more and to, prevent it from happening in the future. So it's not two bites of the apple, because we would not be able to pursue that line of questioning in the arbitration deposition regarding actions beyond the Basari employment dispute. CWDL is not subject to the arbitration, so any potential action that we might take against them would obviously be in this court, and so that is why we're here today.
Response?
Thank you, Your Honor. Yes. First and foremost, there's one or two findings as a court order you must make. One, either that there's going to be a failure or delay of justice, or second, if the burden or the benefit of allowing them to take place outweighs the burden. But importantly, to establish either, it's incumbent and mandatory upon the petitioner, BKM in this case, to actually present evidence supporting a finding of one or the other. We have nothing in this record on that. Their filing, as we've pointed out in our response, is devoid of a single ounce of evidence. You have conclusory statements. Texas law is very clear that the verified petition alone, which is all you have here, is insufficient to grant a Rule 202 petition. Texas Supreme Court has said that these mechanisms, like the Rule 202 petition, should not be used for routine uses like they're trying to here, and that it'd be unfair to allow such a petition to go forward with such conclusory summary statements that don't have any evidentiary support to them. So on its face, this petition should be denied. Now, practically speaking, there is an arbitration with discovery. And if they think they can take a corporate rep deposition of CWDL, and again, I think this is more in line of a harassment, because they keep bringing up Mr. Pfluger, who they then have to acknowledge everything related to him has been settled. Everything he's done, he's not subject to any restrictions. So they went after this most recent employee. If they know anything, they know enough to file on a petition, because they've told you they know of two employees that have left, and they know they've named specific clients. So this is just a kind of a way to continue to harass CWDL on two fronts. One, defend or have to have an employee be distracted with an arbitration that's ongoing, and they have up to 12 hours to take depositions in already. And on the second hand, have to put a corporate rep up.
So my understanding, though, is the arbitration is over, right?
The one as to Mr. Pfluger is, but as to Ms. Basari, we're just getting started and not a single deposition has taken place. So they still have the full benefit of the 12 hours and to take of deposition time.
So respond to that one point. Why don't you just do it through the arbitration?
Because I would imagine that CWDL would object to any line of questioning in that deposition that would extend beyond the context of Ms. Basari's arbitration proceeding. And what we're trying to determine is if there is a cause of action against CWDL that extends beyond Ms. Basari.
Who are the parties to the arbitration?
The parties to the arbitration are my client, BKM Swan Haran, and Saba Basari, who is a former employee of BKM who now works
and
for
nobody
CWDL.
else.
I'm sorry?
And no other parties, just those two?
Correct.
And you want to take her deposition, just her deposition, the 202?
No. The Rule 202 is to, so the Rule 202 petition is take the corporate representative deposition of CWDL. CWDL is a third party with respect to
the arbitration.
The arbitration.
But Your Honor, if I may, I mean, in their own amended petition for Rule 202 depositions, they've said CWDL has repeatedly poached petitioners, employees, and clients. I mean, if they truly believe that, then they have a good faith belief to file a petition. I mean, rather than distracting us with this deposition as this discovery mechanism. And they've said that what they want to do is depose a corporate rep with knowledge of the recruitment and hiring of both Mr. Pfluger, who's already been settled and resolved, as well as Ms. Basari. So again, this clearly is an attempt to make discovery where none should be allowed. They have a mechanism through the arbitration. If they truly believe their employees have been wrongfully poached and clients have been wrongfully taken, they said that in a pleading. That should be enough to go forward.
What is the dispute in the arbitration?
The arbitration is that Ms. Basari has wrongfully taken clients of BKM.
They're not necessarily going to be able to find out if that's a different issue than if CWDL, is that what it is, CWDL, wrongfully stole clients or has a
Well,
the goal or conspiracy to try to continue to steal from the plaintiff, it's not exactly the same issue, right?
I think they're similar enough, Your Honor. They're going to be able to ask Ms. Basari and a CWDL representative about the circumstances by which she was recruited, if at all, or how she came to work at CWDL. They'll be able to ask. They've named in the arbitration 2 specific clients. They say Ms. Basari wrongfully moved from BKM to CWDL. They'll be able to ask about that. That in of itself should give them enough through that.
But it wouldn't be relevant in the underlying proceeding if CWDL had stolen clients. It would only be an issue if the employee had stolen clients, right?
Well, I mean, I guess I don't know what the testimony, how it's going to come out, but if they ask about these 2 clients and how they came about, they will get sworn testimony that either will or will not lead them to believe there's more action to be taken as a CWDL, because they'll get to ask, how is it in one of those clients they've named in the arbitration is called Loan People. How is it that Loan People, and we'll be providing documents on the documents we have that show how Loan People came up.
I agree that like if you look at the Venn diagram of kind of what is needed, what discovery is needed in the arbitration, what discovery would be needed in the 202, there would be definite overlap, but it wouldn't be identical, right?
Would not. I don't think it would be identical. I think it would be a significant amount of overlap, sufficient for their purposes. And I go back to the fact that, again, this is the Texas law says they must come forward with some evidence to support these claims, and they haven't. They just simply haven't. And that in of itself makes their petition procedurally deficient, legally deficient.
I guess my thought is that, to be practical, it doesn't make a lot of sense to do 2 different depositions, one that on the same corporate rep. What makes the most sense would be that you have a Rule 11 agreement to allow in the arbitration broader discovery to make the determination of whether or not a suit is appropriate against CWDL. But are you guys even counsel for the parties in the arbitration? I guess not, because you're not a party. Your client's not a party, correct?
CWDL is not a party. I am representing Ms. Basari as well.
Oh, you are representing her.
Yes.
What do you think of that, Mr. Tufnell?
If we could reach an agreement whereby in a third-party deposition under the arbitration of the corporate rep DL, they would not object to questioning going beyond Ms. Basari into other incidents of possible tortious interference on their part, I think we would be fine with that.
Mr. Hanslick?
I don't have a problem with that, Your Honor. I think, again, I think it's the most efficient way to proceed. And if they, again,
are you guys both
right to object to topics, but I would allow some leeway to go into, I guess, again, we don't know. All we know, they've been very specific about these 2 and this 1 employee. So certainly if they have some questions, I think what they'll find is there's nothing there, but we'll let them explore that. And then maybe if they don't think it's sufficient, they can come back to through an amended 202 or another 202 petition.
Are you guys both local, or are you guys?
I'm in Dallas. I believe Mr. Hanslick's in Houston.
I am. I'm in Houston.
Okay. Well, what I'd like to do is have you guys, if you, there's 1 or 2 options here. One, I think that makes the most sense logically, is for you 2 to enter into a Rule 11 agreement, both that would both be filed in this case and in the arbitration. Is there a separate lawsuit that the arbitration is in, or is it gone through the lawsuit process?
Just AAA.
I assume you can do Rule 11 agreements in AAA.
We can have an agreement, and Judge Ashby is our arbitrator, so she's very familiar with the concept, and I think
she would know about Rule 11 agreements. So I want you guys to prepare a Rule 11 agreement. If you guys can get that done, do you think you can get it done today?
I'm free this afternoon
Sure.
to do them.
So if you, for some reason you can't get it done, what I was going to suggest you come to the courthouse tomorrow morning, but I don't want to make Mr. Hanslick do that. So
I can come via Zoom.
yeah,
not that I can't get to Dallas if I had to, but
no, I don't want to make you do that. So Rhonda,
Yes, Judge.
go ahead and reset this to tomorrow morning at 9. If you
Okay.
guys reach an agreement, you can submit an agreed order before then. You don't need to show up. Just make sure you email Rhonda and e-file it with the court. If you cannot reach an agreement, then we'll talk about it on Zoom and I'll make a final order. How does that sound?
Okay, so just to make sure I'm understanding, the agreed order that we would submit, would that contain the contents of the Rule 11? Or are you asking us to enter into a Rule 11 in the arbitration? And once we
both in both.
Okay.
Because I mean, what makes sense to me is you do one deposition that covers everything in the arbitration, and you maybe even like formally like, okay, now we're going into the additional issues that would be relevant to the 202. I assume it would be the same person who'd be deposed, and you just do them both. I mean, at the same time, so you can get them done at the same time, and have the Rule 11 agreement be entered into both in the arbitration and here. You know what I mean? And then if it blows up or doesn't, if you guys can't reach that agreement, then you come back tomorrow at 9
Via Zoom?
via Zoom.
Okay.
as I understand, we're talking about expanding the corporate rep deposition of CWDL in the arbitration to
Right.
allow some questioning as to recruitment of BKM employees and solicitation of BKM clients.
Whatever the subject matter of this 202 is.
Okay.
And I'll just say this, it's possible I might have 2 reps to cover those things. I just don't know. I don't think it'd be more than 2. But we can handle that logistically, once everything's getting formally noticed.
And you guys are current, and there needs to be something, obviously, I'm sure you guys will think of this, but if for some reason, say the arbitration goes away, then there still needs to be this deposition. So you reach a settlement before you get to the corporate rep, then you still need to go forward with the deposition.
Okay.
That's true. I will say this. I don't see the arbitration going away before we get to the deposition.
Just never know. It seems stranger things. So, all right. Does that make sense, everyone? So if you cannot submit an agreed order, you'll come back tomorrow at 9 on Zoom and we'll chat about it. I'm not going to have a ton of time, so try to get I have a lot scheduled for tomorrow morning, as Rhonda knows. So try to get as much worked out as you can, but if you can't, then that's okay.
Do you want us to file the agreed order per normal and email it to Ms. Pinson, or?
Yes.
Okay.
Both.
Okay, very good. Chris, I'll give you a call here in a second.
Okay, sounds good.
Okay.
All right, guys.
Thank you, Judge.
Hopefully it all works out. Okay.
Thank you.
Thank you, Your Honor.
Bye.
Bye-bye.
Bye.
Mr. Carroll, what are you here for? Mr. Carroll, what are you here for?
The Fields versus Fields case at 3 o'clock.
Okay, we're still early.
It's always fun to go to court.
What did you say?
Always fun to go to court. It's fun to
Yeah.
listen to people argue about stuff.
Oh, you missed the really interesting one we just had about a 202. So,
That's one of my favorite unknown rules.
all right, I'll be right back. Mr. Carroll, can you hear me okay?
I can hear you, yes.
And Miss Fields, can you hear me okay?
Yes, I can. Thank you.
Okay. Are we waiting for anyone else for y'all's hearing today, or I'm happy to wait?
I believe we're waiting for the other side.
Oh, okay, Miss Fields is your client, okay. Okay, we have 2 hearings scheduled for 3. I'm just wondering if we have a complete set on either of them. Ms. Pettit, is everyone here in your case?
Good afternoon, Your Honor. I'm getting my video set up and I'm not sure who will be arguing for the other side. I think it may be.
It's Ms. Christian.
It's going to be Gary Cruciani. I don't, if he's not on, it looks like he's joining now.
Mr. Christiani, are you there?
Yes, Judge Hoffman, good afternoon.
And I think everyone is here for our side, Your Honor.
Mr. Christiani, are you waiting on anybody?
No, sir.
Okay. We have a substitute court reporter today, Ms. Denny. Let's go on the record on
Yes,
cause
I'm
number D. I'm sorry, did someone say something?
I said, yes, sir, I'm ready. Thank you.
Oh, so sorry. Okay, let's go on the record on DC 22490. I'm sorry, that's it. 4908. Dallas Berkshire Partners versus Glass Sellers LLC and Randall DeWitt. Counsel, make your appearances.
Your Honor, Gary Cruciani. With me is Charles Fowler, both with McCool Smith for the plaintiff Dallas Berkshire.
Good afternoon, Your Honor. Julie Pettit on behalf of Glass Seller and Randall DeWitt.
Okay, so typical of lawyers during my experience, you guys are excellent lawyers on both sides, but I asked for one little thing to be briefed, and you guys briefed a lot more. So we're going to talk about the one little thing I wanted briefed on this, which is whether or not plaintiffs should be allowed to replead after they lost on the summary judgment and add a promissory estoppel claim. I don't want to hear any argument on anything else. All other relief is denied. I only want to hear argument on that. So let's talk about that one issue. And I think you relied on LICHTE, that's LICHTE versus Government Employers Insurance. What are the facts of that case?
I'm sorry, Your Honor. Is that directed to me or
Yes,
opposing counsel?
it's your briefing I'm looking at.
Okay, let me just, the case that I was going to address, Your Honor,
Okay.
is because I think this should come down to this. Does the court have discretion to consider our motion for leave in light of its summary judgment order? I believe that's the very narrow issue the court addressed in the case, the Dallas case, that I would direct you to. And maybe I misheard the court. Were you referring to Hakemi, Hakemy?
No, I was looking at Lichty. So which case are you looking at?
Okay, yes, sir. It's Hakemy Brothers versus State Bank and Trust. It's a Dallas case from 2006. And I think that disposes of.
Let me ask this. Is that in your briefing? I'm trying to see.
Yes, it is. Yes, it is, Your Honor.
What page of your plaintiff's motion for leave to file a second amended petition is that?
It is at page 4, the second paragraph on page 4.
All right, let me look at that.
If I can jump in for 1 second, because I guess I'm a little bit confused. To my knowledge, the plaintiffs did not file anything since the last hearing on the 29th. My understanding was at the last hearing, the court directed us to file something by February 5th. My side filed briefing on February 5th on this discrete issue and nothing else. And we did not see that anything has been filed by the plaintiff since then.
I got a notebook from you, Miss Pettit, on the 22nd. I assume that was the new briefing. I guess that's not the new briefing.
They had originally filed a motion for leave and we had originally filed a response. So our notebook has those 2 items in there. In addition, tab 3 of that was the only other thing that's been filed since that last hearing. And that was filed by my side. That was the brief on the discrete issue that the court had requested.
To be clear, we did file on the same day as Ms. Pettit. It's on the ECF. I'm not sure why Ms. Pettit is indicating she did not receive that, but per the court's orders, both sides on the 5th filed the supplemental motions.
We have checked, and I will double check as we're here right now, but we have not seen anything new that was filed.
Let me pull it up. What day did you say it was filed?
On February 5th, Your Honor.
That was February 5th?
Yes, Your Honor, correct.
Okay, maybe I'm confused, Ms. Pettit. Isn't that what you gave me as tab 1?
Yes, Your Honor, they filed the same motion that they had previously filed. There was nothing new that was
It's
filed.
an identical motion. Is that what you're saying?
That's what our review indicated, that it's the identical thing they had previously filed.
I'm not sure if there's a issue with that filing, Your Honor. To my knowledge and understanding, up until what Ms. Pettit is just saying, we filed not the identical motion, but rather a 5-6 page brief on the issue to which you directed us. That's certainly what we intended to file. I don't know if there was some problem or not, but does the court have that in its ECF?
I do not see it. Here, I'm going to show you, Mr. Christiani, and I'm not questioning you. I just don't.
Sure.
I don't know. So I see this brief that was filed by the defendant on February 5th, and then what looks to be is this the motion you're talking about on February 5th?
Well, I'm not sure if you can open that up.
Is this
what that filing is, and if there was.
Can you see it right now? It's the motion for leave to file second amended petition.
If that is what was filed, Your Honor, I will have to take responsibility for whatever happened with the person who was filing that, having filed perhaps inadvertently the original motion for leave.
Can you share screen what you were intending so that we can see it? Maybe
sure. if I could ask Mr. Fowler, who might be a little more technically savvy than me, who's on here, to put that up on the screen if possible. Charles, are you able to do that?
Let me make sure I've enabled it. Just give me 1 second.
Sure.
Go ahead.
Okay, I'm getting there as quickly as I can. Should be able to show you now.
I assume this here is your brief, Ms. Pettit. Is that correct?
Under tab 3 of
Oh,
your
no,
binder, or
but when did you file yours?
the
Yeah,
same,
this is
we
it.
filed our brief on the 5th, February 5th.
So that's what I'm showing right now. Can you see it on the screen?
You haven't clicked on anything, so I can't see.
Okay, I assumed you could see it. Let me try again. Stop sharing. Okay, sometimes it's hard to tell. Okay, what do you see now?
Your Honor, I think what is being shown is what I asked Mr. Fowler to retrieve, which is the brief that we believed we had filed, that we're directed to file on the 5th, the supplemental brief relating to the issue the court
Ms.
directed
Pettit,
us.
have you seen this?
I have not seen this, no. I have not.
Well,
I mean, I'm fine proceeding with the argument because I think there's a Dallas Court of Appeals opinion exactly on point. So though, I mean, admittedly, I've not reviewed whatever they intended to file, but I think
but he
the
said
issue.
he's citing to what was the name of the case? It's on page 4 of this document, I guess.
Yes, if we could go.
I was looking at the document in here and it didn't have it, so I was.
Right, it's Hackamy Brothers case.
So are you familiar with this Hackamy Brothers case, Ms. Pettit?
I am not. I'm writing it down.
And Your Honor, let me apologize, obviously, to the extent what appears happen is inadvertently our initial motion for leave was filed by mistake as opposed to the brief we're looking at. I'm happy to proceed in however the court would like, in fairness, both to Ms. Pettit and to Your Honor, because I know Your Honor likes to, and it's regular practice to read the matters that have been submitted to the court. And again, we take responsibility for a misfiling if that's what apparently happened. But I would submit it might make sense so we could have a more, fulsome discussion with parties apprised of what, the briefing is, to perhaps reschedule this, even if, at the court's convenience. But that's certainly up to the court.
Ms. Pettit, what do you think? I mean, I think it's only, you guys are both excellent attorneys with very good reputations, have always been, you're not the type to do, I've seen attorneys before do kind of what's happening here, where they said, oh, I did file it, and they never did. But I don't think that's Mr. Christiani. I think he's an excellent lawyer with a very good law firm. I don't think this was intentional, but I also don't think it's fair to you to bring this briefing up at the last second. So I'm happy to reschedule.
Sure. So we currently have a trial date set for March the 6th.
Okay.
Is it the 26th? I thought it was the 26th.
I think it's the 20th.
Oh, I'm sorry. It's the 26th. So if we could, I mean, I only need
how much
a day. I'll be ready to go in a day. I don't think this is going to change my opinion. I'm just reviewing briefly what his argument here is, but I don't think it's going to change our analysis. So if I can at least have a day, I can be.
We could set you. Let me just see how bad my docket looks on Friday. I can maybe set, and I don't want to, this is not your fault, Ms. Pettit. So I could possibly set it on Friday or next Monday. I want to give you enough time to. It looks like Friday's not too bad. Let me see. Oh yeah, Friday. That's unusual. Friday's not too bad for me, so I could.
Unfortunately, I'm traveling on Friday, so I will be on flight.
How about Monday, or are you gonna be out of town on weekend?
Yeah,
or-
I'll be out of town next week, but if it's by Zoom, I'm sure I can make Monday work.
This is not your fault, so if you want to set it to another time, I could give this Friday, next Monday, next Friday.
I
or
mean,
the
if you have
Monday
any other
after.
times this week, like I said, I only need maybe a day and I'm sure I can be prepared.
And you said you cannot do Friday?
No, I cannot, Your Honor.
I have a pretty. How about let's shoot for, how about Thursday? Does that work for everybody?
I'll certainly make it work since I'm the one who caused the problem, Your Honor.
Yes, I can make Thursday work, Your Honor.
What time would you like to do? 10 or 2?
And is fine with me. Or 2, I can make either one work.
No, it's not. Okay. 10 or 2, guys.
Whatever. Work.
Same here, Your Honor.
Rhonda, are you there?
Yes, Judge, I'm here.
Go ahead and reset this hearing to 10 o'clock on Thursday.
Okay. And this is the Burkshire,
Yes.
and that'll be the 29th. Okay.
And Ms. Pettit, please get us the briefing as soon as you can. I know it's kind of short notice, but you don't, I guess you don't even have a copy of this. So
I don't have a copy, no.
I think that's up to me to do that, Your Honor. So I will immediately arrange to file the correct brief with the court and serve a copy by email immediately to Ms. Pettit as well. And again, my apologies.
Okay, no worries. These things happen sometimes. So we'll have, and Ms. Pettit, you'll have up until, get it to me as soon as you can, so I can actually read it. But you have as much time as you need to up until the hearing to get it to us. So,
and Your Honor, may I just ask, because just to be clear, you directed that to Ms. Pettit. I think what the court did initially was directed both sides to file sort of simultaneous briefs on the 5th. Ms. Pettit correctly filed it, and we apparently screwed up. So were you anticipating?
No, I guess you're right. You don't need to do additional briefing on it.
Right. Right.
That's fair. So what would be helpful, and I'm going to put Mr. Cruciani in charge of this, is to get me a new notebook delivered to my courtroom by tomorrow morning at 9. That includes all of the correct briefing, as well as any cases that Ms. Pettit would like to include, as well as the cases you'd like to include, so I can read all those.
What I can do, Your Honor, I don't know what Ms. Pettit has already provided. I'm happy to provide copies of both sides. I have a binder of both sides' cases. I'm happy to have that duplicated and have that provided to the court.
I just want to make sure it includes the cases Ms. Pettit wants to have duplicated, so just make sure you get those, add those as well.
Sure. If Ms. Pettit can maybe email me or call me afterwards and let me know what cases she'd like included, and we'll make sure to include those in what we deliver to Your Honor in the morning.
The version of the notebook I got doesn't have any cases, so it'd be helpful to have cases. All right, guys.
All right, thank you.
Sorry, Your Honor, and sorry, Ms. Pettit.
No worries.
All right,
Thanks.
you have a great day, guys.
Thank you.
Okay.
Bye.
All right, Mr. Carroll, I think we have everyone here on your matter with the Fields case. Is that right?
I believe so, yes, Judge.
We're here.
We're here.
All right, let's go on the record on DC 242263, Fields v. Fields. Counsel and parties make your appearances.
James Carroll for Terry Fields.
Letitia and Chad Fields.
All right, let's proceed.
Judge, in this case, I don't believe that they can indicate that they were in adverse possession. The Civil Practice and Remedies Code indicates that they had an actual and visible appropriation of real property commenced and continued under a claim of right that is inconsistent with and is hostile to the claim of another person.
Well, let's jump. Let me just jump in on the first issue I really have here, which is, and I'm getting a lot of people filing this type of motion, and I'm just not sure that this is the correct procedural mechanism to deal with a claim of adverse possession. Like, I could see you filing a motion for summary judgment. I could see you filing, having a trial on this, but a suit to remove fraudulent liens, I'm just not sure that's the right procedural mechanism for this. Do you have any case law that's allowed this provision out of the government code to be used on an affidavit of adverse possession?
I have not found any so far. I mean, I was faced with, the court had set this for a hearing, and so I was sort of waiting for the court to give us some direction. We could certainly do whatever you'd like us to do. I can research and send you a brief. But I mean, in general, my client rented this house to Mr. Fields, and that's clearly not hostile to her because she was his landlord and he was paying rent.
Just to object, Your Honor. I'm sorry.
Well, prior to that, Your Honor, we want you to go ahead and finish and whether or not this is the right mechanism of dealing with this, like you stated. We do have proof otherwise of everything that the attorney stated, but we want to make sure we're in the right court with this and that this is the right type of situation we need to be in.
I'm not saying you're not in the right court. You're absolutely in the right court. My question is this the correct procedural mechanism? So I don't want to be unclear. I don't think that he's filed it in the wrong court. This is an issue of title. District courts are the exclusive venue for issues of title. I'm just not sure this is the correct mechanism. So what it says in the affidavit of adverse possession, let me go ahead and share screen this to make sure we're all on the same page. Yeah. Give me 1 second. Let me go ahead and share screen this. Can you all see that?
Yes.
Yes, sir.
It says, my claim of title to this property is based upon home being stated it would be left in my name from the will of Terry Fields' mother. I have paid the bills and taxes since January 2009 until my wife, Letitia, I'm sorry, I don't know how to say that, Letitia?
It's Letitia.
Letitia, sorry, moved in 2015, which we paid together. Terry Fields has not stepped inside of the home since 2009. So this is kind of an unusual procedural mechanism for just so I know we have a number of parties here. I always think it's interesting to look at because whenever you see the Court of Appeals address this section of the code, they talk about the history of this section, which was to deal with claims where it was usually a group called the Texas Republic, but a group that would file fraudulent liens on people's property and kind of hinder their ability to transfer it where there was no basis whatsoever to do it. And an affidavit of adverse possession in and of itself, I'm not sure is governed by this provision anyway. It's not really a lien unless there's case law. I just did quite a bit of case law and research on this on another matter. This provision has been popular lately in my court. So what I think needs to happen right now, Mr. Carroll and the Fields, is for somebody to research this to show, hey, can this even be used in a claim for adverse possession? It doesn't. it doesn't seem like this is the right procedure, but I'm open to taking a look at it. There's been quite a few cases out there where people have tried to use it for, like, when they say there's been a fraudulent deed filed or something like that. Courts have typically said, no, that's not a correct procedural mechanism for this. This is to deal with fraudulent liens.
You can file something by Wednesday afternoon.
I'm sorry?
File something with the court by Wednesday afternoon at 2 o'clock.
Oh, you don't have to do it that quickly. So right now, this case, we need to kind of figure out, first off, if this is the correct mechanism, then this can be disposed of, just so the parties know, because it's a weird provision. You cannot have a trial on one of these cases. I, as the judge, have the responsibility to look at the documents, and if on their face they're fraudulent, then I can grant or deny this request. There is no trial, there is no testimony under this procedure. And so I just want everyone to know that's why this procedure is used so infrequently, because we want to be able to provide people due process. A claim for adverse possession is usually very fact intensive to make a determination of, you have to be able to make a determination of what exactly the facts are and do you qualify. So anyway, I'm happy to let both sides, not just Mr. Carroll, but both sides brief this issue. And if it's not, Mr. Carroll, as you know, and opposing counsel, so both sides know that this petition could be amended to bring a regular claim forward. And so, does that make sense?
Yes.
Yes, sir. And I guess a question for us is, any proof that we have backing this, do we need to just send it to you, or do we just wait until, I guess, Mr. Carroll figures out what court he wants to try this in, or how he wants to proceed, I guess. Sorry.
Yeah, let me say again, we are in the correct court. I'm a district court judge. District court judges are the exclusive courts under Texas law to hear issues of title. This is an issue of title. You guys are in the right court. It is the right procedure. So I just want to make that 100%. I'm not saying that and let me just ask this, Mr. Carroll, but who brought this anyway? Mr. Carroll, are you defending this or are you bringing this?
My client had filed the motion for leave or motion. She had filed a motion for judicial review of documentation or instrument purporting to create a lien or claim on property.
Okay, I was reading the original. It didn't look like an attorney prepared it. So,
form in the courts.
I'm sorry.
Form that they have in the courts for people to fill out.
Absolutely, you're absolutely correct. I wasn't criticizing anybody. I was just saying it didn't look like. Usually, when an attorney submits it, doesn't look like this. So, I just wanted to make sure I was clear on everything. So, either side, both sides can brief this. When do you want me to reset this for hearing? Both sides.
We honestly, Your Honor, could we request at least 2 weeks?
That's fine.
Okay.
And then in the meantime, like I said, the proof that we have, do we forward that to you, and how do we forward that to you? Or do we need to bring it to your court?
I'm not explaining this very well, and I apologize because this is such a weird. I mean, even for lawyers, this is kind of hard to follow. There is no evidence I can consider. There is no testimony I can consider under this procedure. The only thing I can look at is the instrument that was filed, which is the affidavit of adverse possession. That is it. And I have to make a determination looking at that document and nothing else. Is that a fraudulent lien that was filed or not? And so any other evidence is really kind of irrelevant at this point.
So anything backing what we stated in the document?
I'm unclear what you're saying.
Well, what we stated in the document, we have information backing everything we stated in the document if necessary. And then also for the affidavit of
In the
adverse
doc,
possession.
are you saying in the affidavit of adverse possession, what was filed in the affidavit of adverse possession?
Yes, yes, sir.
That's what you're talking about. Okay.
Yes, and then any questions or the claims, I guess, that the plaintiff has stated to her attorney, anything that we can show proving otherwise.
Let me just, okay. I know this is really complicated, so I'm not trying to fuss with anybody. So the way this works is all I can look at is the document, not any additional evidence. And I have to make a determination is that document fraudulent? Is that the finding of a fraudulent lien? I can't consider anything else. And so, and if it is a fraudulent lien, that doesn't mean you no longer, let's say I do determine that's a fraudulent lien, then that doesn't mean that you can't file a lawsuit for adverse possession. It just means that that affidavit is removed from the district clerk's deed record. So does that make sense? It doesn't dispose of the issue. It just removes that affidavit from the record. Does that make sense?
What you
Correct,
might
yes.
consider is there's a companion case to this in the county court number 4 under, and you might consolidate that with this. They've pled for adverse possession in that court as well.
Can they do they have jurisdiction over this? They don't, county courts can't decide issues of title, right?
Yeah, that's in a different court, correct?
That's a different court for a different case.
Yes, sir.
I mean, if you're making a claim, I don't know anything about this other case. My thought is if you're making a claim, and hopefully the county court, the law judge will see that, if you're making a claim for title, that should be in district court. That shouldn't be in county court. I don't know what else is in that. It may be a claim for possession as well, and then maybe they can hear that. But if it's just an adverse possession, to me, that's an issue of title. But anyway.
Judge, you might consider then taking the county court at law case and consuming it into this case.
That makes sense to me, but a motion would need to be filed on that.
Well, we have an issue with that, Your Honor, because that's a completely different case. That's for unjust enrichment and not the adverse possession.
And it also wasn't stated with this actual case today either. It wasn't filed.
I agree with you.
Initially.
I'm not going to rule on that issue today. I told him that I've told Mr. Carroll if he wants to do that, he would need to file a motion. You'd have an opportunity to argue it at that point. It's not before me today.
Okay.
That makes sense.
Okay.
I'm not deciding anything today. Rhonda, are you there?
Yes, Judge, I'm here.
All right, I want you to put this case, this Fields v. Fields case, on a 90-day dismissal docket so we can get this thing resolved. And then we're going to reset this for hearing. You said you wanted 2 weeks.
At least 2 weeks. If we can have 30 days, that would be better, but at least 2 weeks.
All right, we'll reset this to March 25th
Okay.
at, let's do it at 3 p.m. again.
Okay.
Judge,
Put it on a 90-day DWAP.
Judge, I'll get a motion to consolidate the 2 cases shortly.
And you can, if you file the motion timely and I don't have any problem with those 2 things being decided at the same time. But I want to make sure that they have proper notice so that they can respond to the motion. Consolidate. All right. Any other questions, guys?
The other question is for the adverse possession with that law that you've stated. Could you tell us what is the statute of limitations for response to that? Hard to find. Sorry.
The statute of limitations for response to what?
When people file the affidavit of adverse possession in the court.
Oh, I don't know.
The response of the homeowner.
So how long do they have to file a suit
Against it?
A fraudulent lien? Mr. Carroll, I don't know off the top of my head how long that is.
She filed an affidavit within a couple of days, so I think it would clearly be within the statute of limitations.
You mean she filed the judicial request for judicial review of the affidavit within a couple of days? Is that what you're saying? Okay. All right, guys. You guys have a great rest of your day. I'm going on to my next hearing, okay?
All right. Thank you so much. Have a great day.
You too. Okay, we're gonna go on to the next hearing. Is everyone here on In Re David Hager?
Yes, Your Honor.
Yes. Yes, Your Honor.
All right, did you guys get a chance to chat?
Yes.
Yes,
What-
Your Honor.
What do y'all think?
We're both in agreement with using the judge that you suggested.
Judge Ginsburg, okay. All right, do you guys have an order for me?
I believe we had one e-file, but we can send it again.
No, let me see if I have it. I don't want to make you do extra work. Here we go. Let me go ahead. I see it. I'll go ahead and work on it. Let me sign that right now. I think you already got his email address, right?
Yes, Your
Yes.
Honor.
Just so I don't have to look it up. Do you have the phone number and email address so I can add it to this order?
I have the email address. It's Carl at Ginsburg AD.
Actually, just give me a second. I'm sorry.
I'm sorry, Judge.
That's okay. That's Carl at
Ginsburg.
ADR group, right? Didn't you say that?
Yes, Your Honor. .com.
Okay. And then do you have a phone number or do I have that on my phone if I need to?
I don't have a phone number, Your Honor.
Okay, no worries. Let me just do that right now. And I want to ask you guys a quick question. So let me just, I mean, I don't know what his thoughts are, but I know if I was the judge, if I was in a situation, he is a tax court judge, which is a kind of a permanent position, but officially a visiting judge, which allows him to do this kind of stuff. It's kind of a good gig. But I would suggest to you, and it's of course up to him how he wants to handle this, that you contact him on his cell number as opposed to calling him, at his work office. That would be my suggestion. Okay, I am signing everything right now and sending it over to the clerk's office as we speak.
Your Honor, just a small, we're very thankful. As a side note, this isn't a lawsuit. It's a quasi judicial act. I'm not, and I'm happy to get an order, but technically it's not an order. There's no subject matter jurisdiction before the court, according to the Dallas Court of Appeals. The court, this isn't a subject matter jurisdiction thing, so I don't know how the court issues an order. I'm not going to complain. It's always procedurally, it's a little difficult. Normally I just say, send out notice of appointment of umpire. But I'm not complaining. I'm just saying there's
I just filled out the thing that was in the system. Is
that would be, as long as Miss Peel's happy with it, that was her document. But there's a San Antonio court that overturned it, said that's not because you don't have subject matter jurisdiction, the order isn't enforceable. Now I'm 50 miles down the rabbit hole, but just
okay.
If
you guys want me to do, I don't really care, to be honest. So if there's something else you want me to do, I'm happy to do it. Just give you a form to do it. I just filled out the form she gave me. So If you have something else you think would be better and you guys agree on it, then I'm happy to do whatever you would like.
Anna, as long as you're happy.
Tom, if you have a, alternate wording that you prefer, that's fine. If you want to file something, or send it to me and I can file it however you prefer.
There's nothing.
You just wanted to say appointments, like umpire appointment, take off the word order. Is that what you want to see?
I just envision, Judge, that you're going to be hearing this over and over and over and over in future cases. The
doesn't matter in
downside.
this one, but I need to be careful in future cases. That kind of.
Yes, Your Honor. That's all.
All right. So let me ask one other question that's kind of fundamental to this case. So does this need to go on a trial docket or a dismissal docket? Is this something that could eventually turn into a trial, or is once the umpire is appointed, that's the end of the case?
In point of fact, we were never served with the lawsuit. There isn't a lawsuit to file. As the Court of Appeals pointed out, there's no lawsuit. This is an informal hearing. And that's consistent with other courts that have also looked at it. Now, I understand you don't have any place to put it unless you file it somewhere, but we were never served, which is the way you're supposed to do it. You're not supposed to serve me. That's why I just did a notice of appearance saying this is an informal deal. I'm just showing up to informally ask the court to appoint an umpire. Now, if you're wondering why we're fussing over it, is because sometimes gamesmanship is actually played where they say, you know what, we didn't really like this and the court didn't have any subject matter jurisdiction. There's nothing that could be waived. Please set that appraisal aside. And it's not, well, you waived it. I can't waive, or a litigant cannot waive subject matter jurisdiction. Now I'm 50 miles down that rabbit hole, but Judge, this is something you're going to keep seeing. And the problem is that the district court clerk hasn't figured out how do we informally assign or deal with the appointment of an umpire. It's a corollary to, like, if two people came and say, hey, Judge, we're madly in love, would you please marry us? We wouldn't file that with the court. You wouldn't file, well, maybe you would a license or something, but you see what I'm getting after when when you don't have subject matter jurisdiction, it's a quasi judicial act. And I'm taking up more time than you probably.
Yeah, I'm not sure where to go with this. So Rhonda, so this is never going to turn into a trial, is basically
correct.
This lawsuit isn't, or whatever this
well, this appointment isn't. I mean, maybe later down the road, somebody will file an action for failing to pay it or for some more things, but this is just about appointing an umpire. Once you've done it, this is finished.
Okay. Do you agree, Ms. Peel?
Yes.
So what happens if you guys want to challenge the umpire's decision? Would that be in this?
We would.
It would be a separate action.
We would have to file a suit to challenge the appraisal.
So can I dismiss this case now then, or?
I would. After you've appointed the umpire, there's nothing more that we've informally asked you to do. He's just saying, please appoint us an umpire. That's it. There is no, after you've appointed it.
All right. So you may be completely right about this. That doesn't fit into my system. So I'm going to put it on a 21-day DWAP, Rhonda. And if you guys change your mind and you want to look at the law and you don't think that Mr. Hamrick is correct, which I'm not saying he isn't, I've not heard this argument before. But you guys can show up to the DWAP hearing in 21 days.
Thank you, Judge.
All right. Anything else, guys?
No, Your Honor.
All righty. You have a great rest of your day.
Thank you, Judge.
Okay, are both sides here on Dallas County Hospital District versus Goldwire?
Yes, Your Honor. Good afternoon. Douglas Turk from Parkland. Ashley Tremaine here for defendants Brewer, Brazio, Files, Greenwood, Heights, Nguyen, Patel, Tran, Uehara, and Williams.
All right, before you do all that, so let's go on the record on DC 231996, Dallas County Hospital District versus Goldwire et al. Council, make your appearances.
Good afternoon, Your Honor. Douglas Turek representing Parkland.
Ashley Tremaine representing defendants Brewer, Brazio, Files, Greenwood, Heights, Nguyen, Patel, Tran, Uehara, and Williams.
Good afternoon, Your Honor. Karina Sanchez Peralta here representing defendant Shelby Reeves.
Got everyone?
Don Ferry here for defendant Jacoby. I don't actually have a motion. I'm just observing for for today.
Okay. So let me just say this. I've reviewed the briefing on this, and I have a couple questions that I wasn't exactly clear on after reading it. And very good job of briefing this by both sides here. So I guess the first question I have is, and I may have misunderstood you, so I'm not trying to fuss with anybody, but my understanding was that when we had our first hearing, was that this has been decided by a number of other district court judges here in Dallas County. Only one I saw cited to on this exact issue was Judge Frazier. Is there other judges that have decided this issue?
So
Parkland?
Involving Parkland, no. These lawsuits have been going on for many years, but they have all either been resolved or settled prior to the MSJ hearing, or in other cases, Parkland has chosen to non-suit before the MSJ hearing. So Frazier was the first and only Dallas County District Court judge to actually reach the stage of a ruling on the MSJ, and then that is currently up before the Fifth Court of Appeals right now.
All right, so that's helpful. I just want to make sure I didn't miss something. All right, so the fundamental question I guess I have here, I know both of you have said that you feel very strongly that this is a summary judgment issue, but I maybe have a slightly different take on this. So we have some of the defendants, I'm sorry, getting this confused. Some of the defendants on this case terminated their contract near the end of their contracts. Is that correct?
Yes, I mean, they vary all over the place, as we put in our motion. Some of them resigned very soon after they began. Some of them resigned very close to the end of their 3-year term. I mean, it's in all manner in between.
So the issue here to me is whether or not this $20,000 payment or whatever you want to, penalty or however you want to describe it, what is the terminology in the case law? A penalty?
Damage clause.
We would call it a penalty. They would call it liquidated damages.
That's right. That's what we're fighting over, Your Honor.
Yeah.
So I guess it really comes down to me is I could see that this would be a penalty. Let's say somebody was on their very last day of the contract and Parkland fires them. And then Parkland wants them to, hypothetically, I know that's not the case we have here, but hypothetically, and then says, you owe us $20,000. I think we would probably all agree, maybe not Mr. Turek, but most reasonable people would agree that that would be a penalty and not appropriate. On the other hand, if you had somebody on their first day, they get all of this free training, I understand it's free, and then the first day of their contract says, I'm going over to Presbyterian, $20,000 doesn't really seem to be a penalty. And so this is how I'm thinking about it. You guys, I'll let you guys argue. So I really don't know how this is, to me, it's a fact issue based on how long the individual served at Parkland. You know what I mean? Because some of them were almost done with their contracts. $20,000 seems like a penalty. Some of them were much earlier in their contracts. $20,000 maybe doesn't seem like such a penalty. Because I do think that Parkland did provide some consideration for this by providing the training. But whether or not the $20,000 is an appropriate remedy would depend on a case-by-case basis. So that is, unless you guys can convince me otherwise, that's how I intend to rule. Now, you may be able to convince me otherwise and say, Judge, you're wrong about this. One other interesting point is that Marsh case you guys cited to. Guess what amazing trial court judge decided that case?
Right.
Right here in the 68th, that we changed Texas law and non-competes, not for the better, unfortunately. But all right. So, Ms. Tremaine, tell me that I'm wrong.
All right, will do. So no, it is not a fact issue. And if you look at the case law, this problem that you've pointed out, right, that the severity of the breach is going to vary pretty wildly depending on when a nurse resigns, right? Like if it's on day 1 or if it's on day 350. The amount of harm that Parkland sustains is going to vary quite a bit, right? As you pointed out. Now, what the case law says is that when that's the case, when the severity of the harm varies, the amount of the fee must also vary. And when it does not, that renders it facially invalid as a matter of law. And you don't, as the fact finder, you don't get into what was the actual harm in this particular case or that particular case. That is a later step in the process that doesn't occur.
In that situation, if that's the law, which I'm not 100% convinced that's correct, but if that's the law, then wouldn't that invalidate every one of these things, every one of these clauses? You
Absolutely.
could never have a clause that would be successful.
Correct. Yes.
And have the courts basically blankly said you can never have one of these provisions? So the case law that we've given you is, I mean, we don't have it squarely at this particular Parkland contract, but there's lots of similar contracts in the case law. And what the courts consistently say is when you have a quote liquidated damage clause like this, and it does not vary according to the severity of the breach, then it is facially invalid. End game. There is no further analysis that needs to be done after that point. So we have argued from the get-go facial invalidity. Now, in response, you'll notice that Parkland doesn't actually dispute this fundamental idea that the severity of the breach necessarily varies. I mean, they say it in their own response brief, right? But they don't offer any explanation or any argument as to why it is that if the severity varies, the fee does not also vary. And in fact, I asked their corporate referee. So share screen the best case you have that indicates that if the liquidated damages clause does not vary based on severity, that it becomes facially invalid and it cannot be enforced in any situation. So I would also, and then what happens in that situation? There's no penalty. There's nothing the employer can do at all, I guess. The contract is declared void and unenforceable. And so those cases are set forth on page 10 of our original motion. It includes cases from, the Supreme Court as well as several appellate courts. This is long-standing case law in the context of liquidated damages. Well, let me take a look at that.
And Your Honor, I can also share screen if that's easier for you. I have them right in front of me.
Go, whatever's quickest.
And Your Honor, most recently, the the Fifth District Court of Appeals recently decided a case that's also cited in our brief, again, going to this very fundamental concept. If the severity of the breach varies, then the fee must also vary. And if it does not, that is a huge signal to the court that what we're dealing with is a penalty. It is not a just estimation of actual harm, because if it was, right, the whole idea here is that we can't enforce a penalty. If this was really a liquidated damages clause designed to compensate Parkland and give a real, true, just estimation of true harm, then you would expect that fee to vary based on how long the nurse was there. And the fact that it doesn't is why we can clearly say this is a penalty. It is not a just forecast of compensation owed. If it was, we'd have a tiered system, and we don't.
And Your Honor,
we know.
Mr. Turek, why don't you, how do you distinguish the Eberts case out of the Dallas Court of Appeals?
So I apologize, Your Honor, I don't have it up in front of me.
Okay, so how do you argue against this point?
So the point is that, I mean, there's some assumptions in the arguments that are being made. One is that it is our burden to establish any of this in the context of their traditional motion for summary judgment. The second thing is that counsel has stated that we've conceded that the damages vary greatly. The evidence that they put forward from some long ago depositions of Parkland witnesses talk about that it's the costs and the expense and the time put into training. That's Exhibit I to their motion at pages 10 to 13. And so
what happened here?
Sorry, my screen, is it gone now?
Yeah, it's gone. Okay.
So Your Honor, we have essentially all of these defendants that are in this summary judgment are in the same position. They've all signed these agreements. They've all gone through training. They've all gone to the point that these agreements do have liquidated damages provisions that apply. And then somewhere along the way, they decide to leave on their own. What we have we do have a $20,000 liquidated damages amount that applies to all the nurses, but that's essentially because all the foreseeable damages are the same at the time of contracting, which is when this has to be assessed.
But what Ebert says, though, is if enforceable, the contracts would exact a payment of $10,000 for any breach of the restricted covenant, whether the breach continues for only 1 day or for 2 years. Under these circumstances, the $10,000 cannot be considered a genuine pre-estimate of the harm to be suffered by any breach. So, I mean, that does seem to be kind of on point to what we have here, right?
Well, I would point Your Honor to another case, also the Bunker case. It is not a Fifth Court of Appeals, but it is a much more in-depth analysis of this. And I apologize, I have one computer with a camera and one with my cases up on it. But in the Bunker case, which the defendant cited, in that case, the court analyzed this exact situation where the defendants were moving for summary judgment, and they said that without a showing by the defendants that there is a difference, it's their burden to show that the one-size-fits-all argument applies and that there is a difference in the damages between the defendants. And so the answer to that argument is—
Can somebody share the Bunker case with me? And what Court of Appeals is this?
It's the Third Court out of Austin, Your Honor. And the site I'm referencing is on page—
Ms. Sanchez, can you share that case?
Yes, I'm trying to pull it up real quick. What page were you saying, Mr. Turek?
It's page 6 of my case. The site page is page 8, page 7 to 8.
Apologies. On page 6 of your response, Mr. Turek, there is no case cites.
No, it's page 6 of the downloaded file. It's site page 7 to 8 for Bunker.
Would you mind giving me the case cite to the case and I can just pull it up like that?
It's 2017 Westlaw 876-374.
2017 unpublished Westlaw 876-374, correct?
Correct.
Apologies, Your Honor. I'm still working on getting it pulled up.
Your Honor, I can read you some of this while we're waiting. I apologize that I don't have it pulled up, but the breaching party in this case responded to the court that a one-size-fits-all provision, it included a one-size-fits-all provision because it imposes a fixed amount of damages regardless of when the breach occurs within the contract term. the court rejects that by saying that there was no evidence presented, by the breaching party that ultimately there was any difference in this situation. And it clearly keeps the burden to establish that situation, or that one size fits all argument on the breaching party when you're moving for summary judgment like this.
I'm looking through your brief. I don't see this case you're talking about.
This is actually in their case, in their brief.
It's in your brief?
It's in, yes, because it actually, I mean,
Says
I'll wait my turn to explain why, but it doesn't.
Can someone just show me this case so I could?
Can you
read it?
see
Is that it? Okay, there it is. Okay.
Yeah, Karina has it up. Key part being here, this last sentence of the highlighted portion. You don't have to show evidence when it's facially invalid.
Actually, no, the key part is the next section 2, that says that the breaching party did not provide evidence that there was truly a one size fits all situation where it would have made a difference. I mean, here, Your Honor, they've admitted in their brief that they've all undergone the nurse residency training. They've all completed the steps that would get them to their work period and their obligations under the agreement. And so they're all in the same position.
Let me just read the rest of this. I'm so sorry. Why don't you keep going down?
Your Honor, is this an okay time for us to explain why this case is not standing for the proposition?
I'm just trying to read it first so I understand it. And then
it's just, yeah.
Keep going. So what was the penalty in this one? Was it a dollar? Was it $500,000 in that case?
Yes, Your Honor. It was liquidated damages in the agreement was written in as $500,000.
They keep going down. So in this one, there's simply not enough information in the record to conclusively determine that the time of the termination would affect the damages to which the non-terminating physicians would be entitled.
And Your Honor, that dovetails with your discussion at the beginning of this hearing, is that there was no effort to put forward evidence that is actually a difference, that it matters during the work period when they leave in relation to the liquidated damages. And so that is probably an individualized discussion. And certainly if Parkland was moving for summary judgment, we would have the burden of proving that. But at this point, the defendants are moving for summary judgment, asking this court to rule as a matter of law. And so they have the burden of establishing that there is a difference in that argument.
Okay. Response?
Certainly. Okay, so here's the issue in Bunker. It's not how Mr. Turk has explained it. What the court said in Bunker was that if, again, same thing I've been saying all along and that I highlighted for you at the beginning of this, if it's facially invalid, you do not have to present evidence of the actual damages, okay? Now, what happened in Bunker was the court looked at the contract itself. So this isn't a discussion of extrinsic evidence. It's a discussion of what the contract can clearly show or not. And what the court said in Bunker was the way this particular contract is written, it's not clear to us that the severity of harm would vary. And the reason for that is that in the bunker contract, unlike in Parkland's contract, the bunker contract recited what the nature of the harm would be, and it included things like replacement costs and so forth. And so the court said, well, replacement costs are going to be the same regardless of when the physician leaves the practice. So we can't conclude from the face of this contract that the amount of harm is going to vary, and therefore it's not facially invalid. And because it's not facially invalid, then we go to that next step where we look at the evidence of actual damages. But the bunker case does reinforce this fundamental point that when it is facially invalid, you don't go into evidence. It's just on the face of the contract. Now, in the Parkland case, their contract, unlike the bunker physician contract, the only thing it references is training costs. It says it over and over. We also provided you with sworn corporate representative testimony that confirms this fact. The harm to Parkland is based on the cost that they incur, the quote investment that they incur in training, and they want to quote recoup that investment by having the nurses work for a particular amount of time. You can tell then from the face of it, the harm to Parkland varies. If we're talking about return on investment varies over time. It's not the same thing as a replacement cost.
I guess my question here, Ms. Tremaine, is that, and again, I haven't read the entire bunker case, but isn't the same, and I guess bunker's not, I don't know where this is out of, but the bunker case.
Austin,
I'm sorry. It's not binding on this court, but in bunker, you have physicians who are leaving that will, I assume, were practicing at a particular facility. And if they have to be replaced, then if you had to replace them for 3 months versus 3 years, it would cost more to replace them for 3 years than 3 months. Isn't that the same thing you have with the nurses?
Absolutely not. And the big difference here, again, is that in bunker, the contract recited those harms. It said, this is why we're going to be harmed, and this is what the liquidated damage is supposed to be forecast. They also provided evidence of that. Parkland hasn't provided any evidence at all. And to Mr. Turk's point about burdens, I've given you a Texas Supreme Court case from 2020 that makes it clear that if you don't buy my argument that this is facially invalid, then the burden does shift to Parkland to produce evidence to show that it was incapable of estimation and that this was a just forecast of reasonable compensation. If Parkland meets that burden, then, and only then, does the burden shift back to us to do that comparison of actual damages versus the liquidated number. None of that happens in this case because it is facially invalid. They admit, they put it in their own documents. The harm is based on a recoup of investment, which means the longer the person is there, the more they recoup and the harm lessens over time. For it to be enforceable, that fee must also lessen over time. And because it doesn't, it is facially invalid. End of story. And I just also want to point out that in addition to this liquidated damage piece of it, we also gave you several other reasons this contract is illegal. We also have the arguments under the Free Enterprise Act, and also that they are void as against public policy because they violate several statutes. I do think that of those multiple bases, the liquidated damages / penalty clause argument is the simplest because the case law is abundantly clear on this. Parkland hasn't carried its burden. The Texas Supreme Court does say it's their burden.
So let me see this. You said there's a Texas Supreme Court case?
Correct. It's the Atrium case.
Can you share screen that?
Yeah, let me pull it up.
That found that the contract was facially.
No, so in the Atrium case, the reason we cite Atrium is to kind of show you how the burden shifting works. And so in the Atrium case, the court decided it was not facially invalid. And so what are the
facts of that case?
It's what?
What are the facts of that case?
Let me pull it up. This is.
Actually, I can point it up.
You got it. Okay, I was gonna say because my internet, of course, is. Sorry. So in Atrium, we have the two healthcare companies. Similar thing, like a contract dispute going back and forth. They're arguing about the validity of a liquidated damages clause. In that case, the court said, again, confirming, in some cases, you don't need to do this exercise. If it's facially invalid, we're done. But in this case, we don't think it is facially invalid, so we're going to go on to these next steps. The next steps are the person trying to seek the liquidated damages has to show two things. One, that it was incapable of estimation at the time the contract was formed, and two, that it was a reasonable forecast of just compensation. If they meet that burden, then it shifts back to the person trying to avoid the liquidated damages. And then they have to show that comparison between actual damages and the liquidated damages.
So what did the contract say in this case? Well, what was the penalty clause?
Can you, Karina, can you roll up?
1 second.
This one was a little different because it was not a personal services contract, but that is a difference without meaning under the law.
So what was the penalty and what were the terms?
Sorry, I'm just trying to pull it up. Ugh,
No, I mean now in the Supreme Court decision, not in.
Oh.
Sorry.
Sorry, 1 second.
Yeah, I say
We're giving you a lot to do here.
all my case text sites too are freezing. Case text appears to be down, which is like the public.
Okay. All right. Sorry, remind me what I'm looking for. I got a little mixed up in between PDFs.
The Atrium Medical Center case.
I have that.
Okay, so judge was wanting to see what the actual contract
there was. Okay.
So
yeah.
Is this a situation, I guess, where you have a blanket liquidated damages clause? What was the penalty? So the contract required Atrium to pay a cancellation charge equal to 40% of the greater of the initial agreement value and the current invoice amount multiplied by the number of weeks remaining in the agreement term. So that is something that could change over time. If there's only 2 weeks left, it would, what's the greater of? Exactly. What's the initial agreement value, I guess?
Well, right. And if you, I mean, again, in this case, unlike in our case, there was more evidence, there was more facts to back up, similar to in the bunker case, right? To say, well, it's not the person, the company seeking to enforce the liquidated damages did more than what Parkland did here to try and show like, look, the harm does not vary and here's why it's not facially valid. So the court says, okay, fine, it's not facially valid. So then we look at what are the next steps we do after that if it's not facially valid, right? And so that's where the court goes down. And if you just do like a control F, Karina, for burden, it'll show you here. The party seeking liquidated damages bears the burden of showing that the provision as drafted accounts for these two considerations. And so the court went through that whole exercise in this case. And in that case, the party seeking the liquidated damages did produce a bunch of evidence showing, satisfying the court that it met those two considerations. So
I get that. I guess I'm a step behind you, which is I'm trying to figure out, as we all know, employment law has changed over time, and it looked like this case out of the Dallas Court of Appeals, I think it was Eberts, basically said that if there's and there's some other cases you cited too that said that if there's a set fee essentially, and it isn't a reasonable approximation, then it's facially invalid. That's the end of the consideration.
Yes. The Atrium case doesn't get into that analysis. Atrium is cited for what happens if you get past that first hurdle, right?
But why does it get past that? Why
it doesn't? I'm telling you, it doesn't. but just in case.
So what I'm trying to get at is, in that case, the Atrium case, why wasn't it facially invalid? Was that just not discussed? I mean, because it does seem like it's the greater of 40% of the initial value or the 40% of the invoices times 40%. I can see how the second one is a very good estimation of what the damages might be. The first part, 40% of the initial value, I'm trying to ferret out, is the law still what you're saying it is, which is something facially invalid if it's gives a set amount.
Yes. Yes. Okay.
And
So
that-
let me
and
show
that's-
you.
So that's why I'm
Let me-
wondering
yeah.
why Atrium didn't find it was facially invalid given that provision.
Yeah. I'll show you the share screen. Okay. So this is the Atrium case, and here's why. The contract in this case did not multiple actual damages or penalize dissimilar breaches with the same broad brush. So because the contract here did not do that, the court said, okay, it's not facially invalid. But it is sort of reinforcing, again, this fundamental point
But
that when it does,
it does though, doesn't it? I mean, if it's
No.
40% of whatever the initial investment is or whatever we just called it, whether you breach on day one or breach on day, 700, it's good. At the very least, you're going to have 40% of the initial value, even if you breach on the very last day, correct?
well,
No, Your Honor. In fact, actually, the provision states that it's based on the amount of weeks remaining. So
Well,
it
it's the greater of 40% of the initial value or the weeks remaining.
yes, Your Honor. But all of them will be based on the weeks remaining under the agreement.
Is that, that's not how I read it. Let me read it again. It says 40% of the agreement value. The agreement value, I'm not sure what that means, or the current invoice amount. So what is the agreement value? I assume that was like a certain number. Is that not a certain number?
Yes, Your Honor. It was a certain number. I don't remember off the top of my head what the number was, except for this was the unpaid invoices. So basically the situation here is that they either pay that 40% of the agreement value.
Right.
And just real quick, it does say the agreement value is based on a time factor. Down here, it says the agreement value is 2,616 per week. So it is based again on how long.
Okay. That's what I get. Okay. So it's not a set number.
No, Your Honor. In both cases, it's not. It's either going to be 40% of the agreement value times the number of weeks remaining. And that agreement value is that fluctuating number. And then, or the current invoice amount, again, times the number of weeks remaining. So in every aspect of it, it's fluctuating based on time left in the agreement or, the weeks remaining under the agreement.
Mr. Turk, do you agree?
I agree that that's what this this case came down to. But if you'll note, Your Honor, the original basis for this case brought in was the burden, and to show that the burden was actually on Parkland in this briefing. But this case is the plaintiff, the person seeking to enforce the agreement, asking for judgment. So of course the burden is on the party seeking seeking that relief. And so ultimately this case doesn't show that the burden is on us unless we were moving for summary judgment. So I mean, I think the discussion that you're having about the terms of the contract itself are accurate, but we've gone off onto something different than what this case was originally brought up as.
So let's go back to the beginning, to that first page that you showed me with the 5 different cases, including Ebert. Let's go back to that page. I'm making your job as hard as possible, Ms. Peralta.
I can zoom a little bit. I know it's kind of far out.
And there's also, just real quick, there is an additional case that we cited in the reply that is not listed in the motion itself, that is directly from the 5th District Court of Appeals over Dallas.
Okay, can you show me that case?
Yeah, that's the Shops at Legacy case.
Does it address this issue about
facial invalidity?
Yeah.
Yes, it does.
Let's see that.
And so I can, it is hyperlinked in our reply brief at.
Oh, I meant to tell you, I think you hyperlinked through Google. We can't open that up on the county site.
Oh, okay. Well, it is cited on page 10 of our reply brief. And the key thing here is, again, reinforcing this age-old concept. Provisions that apply the same measure of damages, regardless of the magnitude of breach, are facially unreasonable. They constitute an impermissible penalty as a matter of law. A one-size-fits-all liquidated damages provision will not be enforced. And in that case, they struck down the clause as facially invalid. And what was going on in that case, this is Shops at Legacy, and this was again between two different businesses, Del Frisco's and then their commercial leasing company. And the contract at issue basically said that if like a competing business to Del Frisco's opened up near Del Frisco's within this same, shopping center, that there would be some set amount of liquidated damages that we all agree on, right? But the problem was that in this case, the way they defined competing business was like really overbroad. And so the argument was that like if someone brought in, for example, a company that sells grills and smokers, like for backyard barbecues, that would violate the agreement just as much as if Capital Grill were to move in next door, even though the actual harm to Del Frisco's in that case would vary wildly between those two experiences. And so the court said, look, clearly there's a wide variance of different levels of harm that could theoretically flow from this. And yet your contract is fixing, it's painting with a broad brush. It's saying all potential breaches, no matter how minor or major, are going to result in the same exact figure. That is the problem. It is facially invalid. We will not enforce it, and they struck it down.
Okay, Mr. Turk, how do you distinguish Ebert's and Shops at Legacy?
The difference is, Your Honor, is because there's an assumption being made in the very beginning of this argument. It's that the harm to Parkland is differing between the defendants, or differing depending on when the nurse leaves Parkland. And there's no evidence from the defendants that is the case. In fact, the evidence that's in the case shows that it's the time period when the nurse is in the training that gives rise to the damages. And so all of these nurses have gone through the same, essentially, training and have caused the same damage.
Isn't it the replacement cost that really, you're not saying that there's more damage to Parkland if the person leaves on day one or the last day of the contract?
That may well be a damage element, Your Honor, but the reality is that we have to deal with what we have before us in this case. And right now, the evidence that they put forward is just that it is the training costs at issue. And so ultimately, what you have before you is everyone has done the same thing. Everyone has gone through training. Everyone has left. They didn't fulfill their contract. And so there's nothing to show that there's a differentiation between one nurse or the other, or even because this all has to be considered as at the time of contracting. There's nothing to show that even among a single nurse, if they leave within a month or in 9 months or 2 years, that there's a difference. And so without that evidence in the record.
Okay, so I've heard argument. You guys both did a great job of arguing. I think this is a very interesting and close call.
Your Honor, if I may.
Wait, no, I'm ruling. So I'm going to go ahead and let me just preface this. I'm going to go ahead and grant the motion. Does that dispose of the entire case?
So, Your Honor, when we filed the motion initially, it was on behalf of, I think, 7 of the defendants, and then we later added in several more. I know there are several others kind of waiting in the wings that have filed their own separate motions, but they're all on the exact same grounds. It is my understanding that it should dispose of all of them. However, from a procedural standpoint, I think the other people would have to file their own motion and then have separate orders.
What I'm asking is for each individual, I guess I didn't place that very well, for each individual defendants who resolves of this resolves their entire case. There's no like counterclaims or anything like that.
There are.
There is a counterclaim, but they are, it's just for a declaration asking that you make this exact same ruling that you've already made. So in order to more quickly dispose of the case, if you grant summary judgment, we would probably just withdraw the counterclaim to get it closed out more efficiently.
So what I'm trying to get at is apparently the Frazier decision is on appeal. Is that right?
Correct.
And how did it get on appeal? Did she grant the summary judgment that the plaintiffs filed? Is that how it worked?
Yes,
correct.
So kind of the flip side of this.
Yeah, she denied ours and granted theirs. So we filed the appeal.
So what I guess I'd like, and when is the status of that appeal?
We have filed our brief, and I think Parkland's brief is due in like maybe a month and a half or so, roughly.
April 11th, I think, Your Honor.
Yeah. And then, we'll file our reply. I mean, we're hoping to get a ruling before the end of the year, but of course we don't know for sure when that'll happen.
So we have a jury trial on August 13th. So let me just kind of, and then this kind of would dispose, I think, of all the rest of the motions set up, right? Coming up.
Correct.
So obviously, I'm trying to think 3 steps ahead here. So if Frazier's decision is upheld by the Court of Appeals, then I would like to reconsider my motion, my order, right? Because it's the same issue.
I don't know that procedurally that would be possible. I mean, I would think what would happen is they would have to appeal.
Okay.
The grant summary.
So I'm trying to think 3 steps ahead. This is this order I'm about to sign is a partial motion for summary judgment because there's other plaintiffs, correct?
Yes, other defendants.
I'm sorry, I keep getting confused. Other defendants. It's going to take a while for us to go through all of those other defendants, for them to file motions, blah, blah, blah. If during the interim, the Court of Appeals, I'm telling this to you, Mr. Turek, Court of Appeals agrees with you and with Judge Frazier on appeal, then I'd like to be able to have the opportunity to review the ruling I made today in light of the Court of Appeals ruling in the Frazier case. Now, there may be some differences. I'm not saying I necessarily will just change my ruling, but I might.
Your Honor, I just don't know. I mean, procedural, because I'll just tell you, like, what we would probably do is if you're granting summary judgment in our favor, to the extent there's other defendants hanging out there, we would most likely move to sever and move to final judgment right away.
And Judge Hoffman would have to agree to that.
Correct.
Judge Hoffman may not want to agree to that because he wants to find out what happened in the Frazier case.
Yeah, but I will tell you also, I fully expect, I know we have several others waiting in the wings right now with their own motions that are currently set. I know Mr. Jacoby has one coming up, and then I will file some additionals for my additional clients that were not included on this initial motion. So realistically, I think those will be heard within the next month or two. There's no way we're going to get a ruling from the appellate court within that time period. And I would love it if we did, but I don't.
So I guess, Mr. Turek, would you prefer, there's 2 ways we could do this. I can just slow march the rest of this so we can wait to get a ruling on the Frazier case, or I can speed march this or force march this, try to get a ruling on mine, and you can consolidate the appeal and have it all heard by the Court of Appeals. Do you have a preference, or do you want to think about that?
My preference would be the slow march. I think it will be instructive to have the direction on, it's called the Parkland versus Garcia appeal. And so I think it would be better to do the slow march than the fast march, but that's my preference.
Okay.
And I would just, Your Honor, if we could just request though, like, this is directly affecting these nurses' lives every day. Like, they're trying to buy homes and do things that require financial disclosures. And they're at this uncertainty of like, is this a valid debt that I have to disclose or not? And it really is important for us to get closure and certainty on this.
But what's going to happen if we do exactly what you say is it's going to go up on appeal, and this case will go up on appeal, and then there's just more stuff on appeal.
I mean, I don't know if that's a foregone conclusion necessarily. But in any event, I would just.
Anyway, all I'm doing today is granting the motion.
Okay.
Telling you what I'm tending to do, just to be transparent, because I really do want to get a ruling out of the Court of Appeals. And since we already have the Fraser case going up, I don't see any reason to have multiple rulings. And so just FYI.
Okay, so we had submitted a draft order previously via e-filing, and the way I had structured that was, to say granted or denied, kind of a fill in the blank type of order. And then it had check boxes for the reasoning, like I'm granting it because da 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 da, and then check the ones that apply. Are you okay using that, or would you rather us submit more of a broad form order?
I don't really care. I want as clean an order as possible. So I want you guys to confer on it, look at, submit a new order with me that reflects that I found this was facially, whatever the wording is, defective, and submit that to me on that basis.
Okay, and then the remaining bases that we argue, just leave those stays. I guess there's no ruling on those.
I'm sorry, again.
So in other words, like the draft order would not say anything about the remaining bases we had argued.
Only that basis.
Yeah, okay.
Get that to me as soon by no later than this Friday. Make sure it says at the beginning this was heard on February 26th. Mr. Turk, I'd like you to see if you can agree as to the form of the order. And you guys have a great rest of your day, okay?
Thank you.
Thank you, Your Honor.
Thank you. Okay, Musaji versus Stafford, are both sides here?
Yes, Your Honor.
Yes, Your Honor.
Let's go on the record on DC 23-14641, Musaji versus Stafford. Counsel, make your appearances.
Your Honor, Lance Kasab on behalf of the plaintiff.
Paul Stafford, subject to a special appearance on behalf of the defendants.
All right, let's proceed.
Thank you, Your Honor. I believe I've said a special appearance as well as in the alternative a motion to quash for today at 4 o'clock. It's 4:26. So wanted to be respectful of the court's time and move expeditiously through this. December 14th, defendants filed their special appearance and in the alternative a motion to quash, along with a motion to dismiss pursuant to Rule 91A, special exceptions, general denial, specific denial, affirmative defenses, request for a jury, and counterclaim. And we come before this court following a 91A hearing, which was some weeks ago. But I wanted to draw attention to the court's, draw the court's attention to the special appearance, which is in the December 14th filing, which is pursuant to Rule 120A1, as the court is well aware. The defendants are asserting that the motion for substitute service and the affidavits in support of substitute service, which were filed October 26, 2023, were without basis in law or fact and were procedurally improper. The order granting the motion for substitute service was also improperly granted on November 16th, 2023, based on that improper motion for substitute service and the inaccurate affidavits in support of the substitute service motion. And the purported substitute service in plaintiff's original petition and citation and any purported service upon defendants was improper reporting. And if I could expound on that, Your Honor, In the March 8th, 2023 grievance against Paul Stafford, which was subsequently dismissed without merit, and in contradiction of all the jurisdictional facts, Mr. Musaji asserts in his grievance, section 4, paragraph 1, that the activity he is complaining of occurred in Collin County in Dallas. To clarify, Paul Stafford's office and the office of Stafford Moore are located in the city of Dallas, Dallas County, and Mr. Musaji's case was pending in Collin County when it was filed on September 25th, 2020, not October 12th, 2020, as is stated in the grievance. This is relevant because in plaintiff's original petition, Roman numeral 3, jurisdiction and venue, paragraph 9, improperly states the county, states that defendants reside in and or have a principal office and headquarters in Harris County, Texas. To the contrary, defendants have never resided in nor had a principal office and headquarters in Harris County, Texas. And so we've requested this special appearance based on that portion of plaintiff's petition, misstating jurisdictional facts. In an email, which is Exhibit 2 to defendants, to plaintiff's response to defendant's special appearance, defendant admits that the jurisdictional facts have been misstated, and as well as the address, indicates that they will correct that. But that doesn't change the nature of the misstatement in the plaintiff's petition or in its reliance upon jurisdictional facts requisite to bring this case before this court. If I may address the motion to quash very briefly in that regard, Your Honor. Pursuant to Rule 120A and 122, the purported substitute service, again, in plaintiff's petition and citation, was improper. The substitute service motion states that twice on September 27th, 28th, and 29th of 2023, Gillespie, who was purportedly the process server, Joseph Gillespie, went to defendant's office where the process server was able to establish the address of the defendants and was unable to serve the defendants, leaving a yellow business card each time the office was locked. The motion for substitute service, it is asserted, it asserts that Gillespie spoke to a lady. Doesn't indicate the lady's name or the identity or where she was employed or even the address in which the person spoke to the lady in regards to the defendants, nor does Gillespie indicate that he stated the purpose of his inquiries to the lady. Mr. Stafford.
Let me just ask a question here because I'm maybe a little confused on this. So usually special appearances, every time I've ever seen them, are to challenge essentially whether or not there's minimum contacts. So do you have jurisdiction in Texas? You know, I just ruled on one of these recently where you had a doctor who was practicing and who's a California resident who's doing business with a Texas resident, and whether or not the activities between them constituted minimum contacts. I've never seen anyone try to argue that you don't have jurisdiction because there's an alleged defect in service. And so I guess I'm not kind of familiar with how you're approaching this. You said you were relying on which rule again?
Well, I'm relying on several. For the appearance or special appearance, it's Rule 120A1, and for the special appearance in relation to the motion to quash, it's 120A and 122 and 106 and 107. But if I just may finish briefly, Your Honor, perhaps it'll clear this up. If I may proceed.
I'm just trying to figure out what we're doing here. Can Rule 120A be used for service defects? I've never seen it used that way.
Well, there's no prohibition to that, especially when the jurisdictional venue facts are misstated in plaintiff's petition as Harris County, which is not where we are.
But, I mean, that would be, that would be dealt with through a motion to transfer venue, not a special appearance, right?
Well, it could be dealt with motion to transfer or a special appearance.
Or special exceptions.
Or special exceptions. Or a motion to quash, which is, we've chosen to deal with it through special appearance and motion to quash.
Let me just ask this. Sometimes I get up on a rabbit hole and maybe I'm missing. Mr. Kassab, do you agree that this is the correct procedural mechanism to deal with the issues that Mr. Stafford has addressed, that you misstated the venue and you also, there was allegedly a defect in the subservice? Do you agree that a special appearance is, I just have never seen anyone use it that way. Do you agree that's the correct procedural mechanism?
There are other aspects to it, but if
let me just hear from Mr. Kassab for now.
Sure.
Not at all, Your Honor. That's why we filed a motion for sanctions. We think it's completely frivolous for various reasons.
But do you agree that this is not the correct procedural mechanism to deal with a defect in service, if there is one, and a problem with venue?
I agree that this is not the proper procedure.
Okay. That's kind of what I thought too. All right. Mr. Stafford, did you want to say anything else?
Sure. Yeah. May I proceed, Ron?
Yeah.
On the motion to quash, which is in conjunction with the special appearance today, again, the assertions in the motion don't give any specificity as to who this lady was, nor does indicate the purpose of the inquiries. The hearsay comments in the motion, which are used, the affidavit is used in support of the motion, are inconsistent with the affidavit itself.
Let me make sure I'm kind of understanding this. So you guys were served and you filed did you file an answer? I assume you filed an answer, right?
I was never served. I'm getting to that, but I was not served.
But you did file an answer on 12/14, correct?
In the alternative to the special appearance, yes or no?
Okay.
May I proceed, Ron?
And you're trying to quash the original substituted service, is that what you're saying?
Along with the special appearance, yes or no?
Okay.
May I proceed, Ron?
Okay, yeah.
The statements relied on in the motion regarding the number of attempts, leaving of a yellow business card, and Gillespie speaking with the lady are not contained in the affidavit. They're not contained in the affidavit supporting the motion for substitute service. Also, there's a fatal variance between the hearsay and the motion and the affidavits itself, pursuant to 106 and 107, which requires showing of due diligence and a requirement of a sworn support for any accurate statement for granting a motion for substitute service. The affidavit and the motion are completely inconsistent, which is a fatal variance. The motion requested substitute service by posting said information on defendant's door, 325 North St. Paul, 2210 Suite, Dallas, Texas, 752013. This isn't the address of either defendants. In addition, the motion states that plaintiff further requests the court to authorize plaintiff to serve defendant at defendant's email address. It only cites a single email address with no indication the service to email was reasonably effective to give defendants notice of the suit as required under 106B or 107 when email service is attempted. In addition, and this is very important, regarding defendant's website and presumably in an attempt to corroborate the single email address plaintiff attributes to defendants, the motion footnote 6, that's plaintiff's motion footnote 6, inexplicably references other cause numbers, including cause number 2021-42032, which is the case of Desdiak versus Hager in the 129th Judicial District in Harris County, as well as another cause number 2019-72271, which is Heather Martinez Sanchez versus Mosier in the 295th District Court in Harris County. And these are two cases that the defendant is not listed as attorneys or has any involvement with whatsoever. And just bringing this point to a close, Your Honor, the affidavit of service filed on November 21st, 2023 states that service was perfected on November 20th, 2023 at 3:20 by serving Paul Stafford at the address of defendants. That's not defendant's address, nor is it Paul Stafford's address. And it says that he was personally served in this case. I've never been personally served in this case, Your Honor. Based upon the foregoing, we're saying there's a fatal variance between the motion for substitute service, the affidavits, as well as a jurisdictional issue with the misstatement of the Harris County versus Dallas County. Again, I'm bringing these in conjunction, and I believe one of the arguments was that somehow this has been waived. Rule 91A, point 8 specifically says you don't waive a special appearance simply by filing a Rule 91A motion. And so any assertion to the contrary is without merit. And I would ask that the court grant the special appearance as well as a motion to quash based on the pleadings as well as the argument presented before today.
Response?
Your Honor, as the court is aware, a special appearance is made by a party for the purpose of objecting to jurisdiction of the court over the person or property of the defendant on the grounds that such party or property is not amenable to process issued by the courts of this state. Here, the Supreme Court in Dawson-Austin v. Austin, 968 Southwest 2nd, 319, jump site 322, provides guidance with regard to a general appearance. And it states that a general appearance, when you make an appearance in the court, can constitute a general appearance when one of three things. One, the party invokes the judgment of the court on any question other than the court's jurisdiction. Two, recognizes by its acts that an action is properly pending. Or three, seeks affirmative relief from the court. And Judge, the test for a general appearance is whether a party requests affirmative relief inconsistent with an assertion that the trial court lacks personal jurisdiction. There are several things here, Judge. Number one, under 120A, the special appearance must be sworn. There's no sworn verification attached to the motion. That's number one. That kills it right there. Second, he's filed a motion, a 91A motion to dismiss, and asked the court to dismiss this case completely based on an estoppel issue with regard to the grievance that he mentioned earlier, which was denied. And also, he's filed a counterclaim, Your Honor, where he admits that he resides in Dallas County, does business in Dallas County, and that the court has jurisdiction over the counterclaim. So I get there may have been some typos in the petition. I've told Mr. Stafford to be happy to change that and make it correct, but that's a special exception, not a special appearance.
All right, so I'm going to deny the special appearance. I'm going to deny the motion to quash. I am going to say, Mr. Kassab, to save us all a lot of time, can you just amend the petition to, obviously he does not reside in Harris County, so that obviously was a typo. I don't want to go through don't force him to go through a special exception. Don't have us go through a motion to transfer venue, because I think we all know that Mr. Stafford resides here. So forcing him to file a special exception, I just want you to practice in my court very much. So I'm a very practical judge. If you force him to file a special exception at this point, after you know that there's a mistake, that's where you can come into sanctions. So you need to fix that.
Your Honor, I've told him I'll fix that. The only reason I haven't thus far is because he had the 91A motion pending, and I didn't want to move that hearing.
Okay, I'm just saying. I'm just trying to give you fair warning. Fix that so we don't have to deal with the motion to transfer venue or a special exception. It's
and
a
Your
mistake.
Honor,
Wait.
I'm sorry, my apologies.
Talking to Mr. Kassab. So fix that. And so we don't have to deal with the motion transfer venue or special exception. And I want you to fix that as soon as you possibly can, because that clearly is a mistake. Don't force them to do that. I'm not going to grant sanctions at this point. And that's it. Guys, you have a great rest of your day.